Hello and welcome back. This first video is going to be a little bit different because we're starting in the middle of where we left off right before spring break. That's on the lecture in the American Experiment, Confederation versus Federation. So I'm going to start with just a recap of what this whole lecture is about. In 1776, American revolutionaries exerted a radical idea of sovereignty. They rejected the Bible's idea of sovereignty based on divine right and accepted the ideas of John Locke called social contract theory. Social contract theory says that humans, not God, creates a government. The problem the Founding Fathers had was a practical application of social contract theory. They had very little to go on. Social contract theory could only be found in a few examples in history. Those examples came from the ancient world, communities with about 5 to 100,000 people. By the time of the American Revolution, the 13 colonies had 2.6 million people. That was much larger than any of the previous examples. So the Founding Fathers had to find out how they were going to make social contract theory work. That was their problem. They turned to English history, ancient history, and Enlightenment philosophy. The solutions they came up with were varied, but their primary focus was on a fear of a monarchy, and so they concentrated on creating a weak central government. That turned out to be a failure. They were going to break apart. They were divided amongst themselves, and so they decided that they were going to strengthen the central government. So we've already done Articles of Confederation. In the Articles of Confederation, each state had sovereignty, and that was too weak. So they turned then to the drafting an American or U.S. Constitution in 1789. And those features strengthened the hand of the central government, making it the supreme law of the land, and creating a federation in which the states had to share power with the central government. So to finish the recap, we've already started and finished the Articles of Confederation. In a confederation, each state was sovereign. That proved too weak. And so the Founding Fathers went back to the drawing board with social contract theory. They reworked the social contract and came up with the United States Constitution, provided for a federation in which states had to share power with the central government. This union became the supreme law of the land. Once that was put forth for ratification, as we're going to see, the Bill of Rights then put restrictions on that central government to protect individual liberty. So we've already covered the Articles of Confederation, we've started on the United States Constitution, and we will finish up with the Bill of Rights. So this particular video is going to finish up on the U.S. Constitution. The U.S. Constitution begins with a beautiful phrase: "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." That phrase, more perfect union, shows that the Articles of Confederation did not bind the 13 states together strongly enough, and the framers wanted to increase the unity or the union so that all 13 could act as one and not go their separate ways. So this is a federation, a composition of individual states in which each member state shares sovereignty with the central government. So how does that work? Well, Article 6, Clause 2, the Constitution and laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. The judges in every state shall be bound therein, anything in the Constitution and the laws of any state to the contrary notwithstanding. So, no judges in the states and no legislature in the state are allowed to contradict laws made under the Federation. This is the supreme law of the land. So once the Constitution is invoked, constitutional supremacy, the federal government is the last say, not the states. It was fundamentally different than the Confederation, in which each state retained their sovereignty. This strengthened the hand of the central government. So, Article 1 gives Congress the powers. So the Congress shall have the power to make all laws which are necessary and proper for the execution of the foregoing powers. The Congress shall have the power to make all laws which are necessary and proper. So this necessary and proper clause is a very broad clause that empowers the Congress to take action to protect the American people and to promote our well-being. The Constitution also addresses the states. So the full faith and credit clause says that states must respect contracts made in other states. You don't have to renegotiate contracts from one state to the next. When someone goes into debt in Texas, that debt cannot be escaped by moving to Oklahoma. Anyone escaping service or labor had to go back. This was a way for the Founding Fathers to avoid the sticky issue of slavery, and so they used politically correct words like service and labor so that no one would get upset that they were actually talking about slaves. Each state had to have a republican form of government. That word republic is very simple. It means that it has to be a representative form of government. It binds each state to a representative government in which voters select elected officials. It's a republic, a res publica, a public thing, not a private thing. Article 6. The senators and representatives before mentioned and members of the several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall be a qualification for office. So we've already seen that in England, the Anglican Church was the test. Parliament had passed a test act that only members of the Anglican Church could serve in government. The Founding Fathers rejected this idea. No religious test. So it doesn't matter what religion a person professes. The government must remain neutral when it comes to qualifications for office. Anyone from any faith can run for office in the United States. This was a radical departure from the established churches in Europe. To prevent tyranny under this Constitution, the Founding Fathers turned to a system of checks and balances. That phrase was found in Polybius' Histories of Rome, an ancient document, an ancient history about the Roman Constitution, the Roman Republican Constitution. It was also found in a contemporary argument made by Montesquieu, an Enlightenment philosopher, in a book called The Spirit of the Laws. These features, if you also look at them, resemble what the Founding Fathers experienced under English rule. So this system was not novel, it was not unique, but they turned to English tradition, ancient history, and Enlightenment philosophy to write their social contract into law. So first, you have the legislative power. Second, you have an executive power. Third is a judicial power. The legislature makes the laws, the executive enforces the law, and the judicial decides if the law has been broken. So what does that look like in practice, right? That's a theory. Let's get the practical aspect. The United States Congress has the lawmaking authority. It is the legislative branch. It's a bicameral system with a House and a Senate. The House is a people's body. Each state has a proportional number of members. Big states have more members. Small states have fewer members. Each state has at least one. Voters directly select the members of the House. The Senate, on the other hand, the upper house, is a little bit different. Each state has 2 members. Under the original Constitution, the Senate represented the states. That's since been amended and modified, but let's talk about the original part first. The Senate, under the original Constitution, the state legislatures selected the senators so that the states would have a voice in Washington. Now, a subsequent amendment to the Constitution took that power away from state governments and gave it to the people of the states. But under this original Constitution, this feature demonstrates the federal nature of the United States Constitution, that each state legislature, each state government had a voice what was going on in Washington. The president is the executive power. He enforces the laws. So Congress makes the laws. They make the decisions. The president is responsible for then enforcing the decisions that Congress makes. Last but not least is the Supreme Court. The Supreme Court decides if the law has been broken. So Congress makes a law, the president can accuse someone of breaking the law, it then goes to a federal court and federal judges decide if the law has been broken. They are the supreme judicial power in the land. Now, one of the features then is, who do you count as people? Does everyone count as a person? And so this prompted what is called the 3/5 compromise, that the southern states had slaves. They wanted them counted in terms of apportionment. They wanted them counted to have political power in Washington, even though the slaves did not have a political voice in their own states. So they wanted something for themselves that they did not want to give to their slaves. In order to hold the Union together, this became the 3/5 compromise. Under the Constitution, slaves were considered 3/5 of a person. Now, they didn't say slaves because, once again, that would have been politically incorrect and upset some people. So instead, they just referred to people in involuntary labor. Other than that, we have the basic powers of the Congress. The Congress has the power to budget, the power of the purse. Once again, that is something that the House of Commons and the House of Lords had extracted from the monarchy. And so the House of Representatives, House of Commons, the Senate, House of Lords, has the budgetary power, the power of the purse. One of the biggest expenses of a government is to wage war. And so Congress gets to decide to go to war. Congress also has authority over interstate commerce. This took power away from the states. Under the Articles of Confederation, right? Under the Confederation, where each state was sovereign, they could decide issues of interstate commerce and place taxes or tariffs on goods going out in and out of any particular state. This was removed, and that power was then transferred to the federal government. So what does the president get to do? Well, the president is in charge of a cabinet. His cabinet members are the ones who enforce the laws. And so the cabinet makes sure that the laws of the Congress are faithfully executed to the best of their ability. The president then has, through his cabinet, the power to spend money, the power over expenditures. Those expenditures must be first appropriated by Congress. Once Congress appropriates the money, then the president can spend the money. Finally, the president is commander-in-chief. That's a very powerful position. the Commander-in-Chief of the Armed Forces of the United States of America. This is similar to monarchical power. Monarchs in Europe were in charge of armies, and so here we have the president in charge of armies. But he must obey the decisions of Congress. Congress has the authority to make laws governing the military. Congress has the authority to budget and appropriate spending. Congress has the authority, has the power to declare war. So the president, his power is checked and balanced by the United States Congress. Congress makes the decision, the president enforces that decision. If the president doesn't like what Congress legislates, he could try to veto. Veto is a Latin word, once again, coming from Latin history, Roman Republican history, which means I forbid. Literally, veto. The O is the I in Latin. I forbid. Now, Congress passes a law, goes through the House, goes through the Senate. He vetoes. I forbid. But is that the end of the story? No, because Congress can override a presidential veto. The House and the Senate, acting together, can tell the president that they have more power. That's an important concept. Because if the president stands in Congress's way, if the Congress comes together, the Congress is the last say with the law. But only so much. Because the law can then be challenged in court. Under the Constitution, the Supreme Court is very vague. It is the least defined of the legislative branches. And so it is explained in documents such as Federalist 78. In Federalist 78, it asked a very simple question. What if there's a matter of constitutional law? What if Congress or the president is accused of violating the Constitution? Who would decide that? Well, the framers of the Constitution said, well, that would not be an issue for Congress to decide because Congress made the law. That would not be an issue for the president to decide because the president enforced the law. That obviously, if there was an issue of constitutional law, did the president or did the Congress violate the law? Did a state violate the Constitution? That would be settled in the federal courts, and ultimately the supreme decision, the sovereign in cases of was the law broken, would be the Supreme Court of the United States of America. Now, that actually came to a head in a case of Marbury versus Madison. Someone accused the president of violating the law, and it was then challenged in court, and the Supreme Court established the precedent of judicial review. So here we have a system of checks and balances that is founded on ancient history. It's founded on contemporary Enlightenment philosophy, and just as much founded on English history, English political tradition. So there you have it, the Constitution of the United States of America. A federal system in which the states must share power with a central government. A more perfect union. It shifted power away from the states to the central government under a definable set of laws and principles, allowing the nation to act as one when they come together to unite behind a common cause. This was something that was prevented under the Articles of Confederation, so that they feared a monarchy, but instead of that fear of monarchy driving them towards a confederation, which had failed, they then turned to a federation to better protect their needs. This is exactly how a social contract is supposed to work. If it doesn't work, the people get to rewrite it and redefine it in their own interest, in their own time, through their voting and through their legislature. This is a republic, not a divine right monarchy.